So what's one thing is quite clear, that the paragraph 3 dealt with factions. An argument to say that I am the party is contrary to the constitutional framework, because he is not the party. Because the party is registered under section 29A of the Representation of Peoples Act. The office bearers of the party are communicated to the Election Commission. And the constitution as accepted is the final document. He can't now say, I am the party, because the party with the Election Commission and the party with the speaker is only the members of the legislature belonging to that political party. So you can't say I am the party. So that proposition is unfounded in constitutional law. Thus, paragraph 3 as it stood, I'm sorry, you also have that?
Yes.
Yes.
Thus, paragraph 3 as it stood recognized a faction of the legislature party arising as a result of a split in the political party. And your lordships have now read all the documents. Till July the 4th, is there any reference to any split? No reference. No mention of split. The effect of deletion of paragraph 3 from the 10th schedule is that the Constitution does not recognize any faction, whether it consists of majority or a minority of the members of the legislature party. Why? There's a constitutional basis for that also. I tell you just why. When I seek election directly from the electorate, I don't seek election in my personal capacity. I seek election on the symbol of the party. In my activity in the House and outside the House, I continue to be a member of that party and must honor the discipline that's imposed on me. So, in the relationship between the legislature and the political party has primacy. The legislature party has not primacy. So, when you are interpreting the Constitution, you have to give primacy to that political party whose representative I am in the legislature. You can't in the process give primacy to the legislature over the political party, which the other side is trying to do, by saying, I am the party. It can be one member of legislature, but can he say, I am the party? So within the constitutional framework, the will of the legislators, in fact, is subject to the functioning of the political party both inside and outside the House. Now, he can have dissent outside the House, but no dissent within the House, which is why the whip. Because there he represents. That's why Holohon says you can't go against it. Parliamentary democracy only recognizes alliances between political parties, and not an alliance between a political party and a faction of a legislature party. That'd be constitutional harakiri. The Sarkaria Commission's recommendations approved by this Honorable Court in Rameshwar Prasad also categorically emphasize the importance of sanctity of the party system and states that the governor, in arriving at a satisfaction to invite a chief minister, can only recognize alliance of parties and not an alliance of a party, in this case the BJP and rebel MLAs of another party. Para 4.11.04 of the Sarkaria Commission report specifically deals with a situation where no single party obtains absolute majority and provides the order of preference the governor should follow in selecting a chief minister. Now, this is final. What does it say? The order of preference suggested is 1, alliance of parties that was formed prior to the election. So parties, alliance of parties. 2, largest single party staking a claim to form the government with the support of others, including independents. Again, largest single party. 3, post-electoral coalition of parties, with all the partners in the coalition joining the government. And 4, a post-electoral alliance of parties, with some of the parties in the alliance forming a government and remaining parties, including independents, supporting the government from outside. There is no space for factions when the governor has to appoint a chief minister. Now, if all of Shiv Sena had gone to the BJP, governor will call for a floor test. If the Shiv Sena itself had gone. Now, this is cast in stone. Now an argument is being raised, it doesn't matter, and which is why, Malad, I said to your lordship the consequences of it. Malad, supposing 2 or 3 members of each political party who don't form the majority go to the governor and say that support of six of these people reduces the chief minister to a minority, therefore call for a floor test. Malad, it would be disastrous for democracy. That's the Airam-Gayavaram principle that we gave up. 50 members of BJP today, Malad, support Uddhav Thackeray. Will he call for a test? So, Malad, the whole propositions, the propositions that have been advanced by my learned friends are all contrary to basic principles of constitutional law. It is respectfully submitted that under the constitutional scheme, a member of a legislative assembly set up by a political party does not have any independent identity in the House. Dehors the political party on whose ticket he is elected to the House. The same is clear from the following. Now, this is important. Kindly see Article 170 of the Constitution and kindly see Sub-Article 1. Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500, not less than 60 members chosen by direct election from territorial constituencies in the state. Well, I mentioned that to your lordships yesterday. Delimitation Commission, territorial constituencies, direct election from the territorial constituency. And undisputedly, in the present case, the group of the Shiv Sena legislature party, represented by Eknath Shinde, is a faction of the legislature party, albeit a majority. The recognition of a majority of Shiv Sena MLAs by the governor to entertain a doubt about the confidence enjoyed by the government is in the teeth of the provisions of the 10th schedule and of the constitutional scheme related to election of members to the Legislative Assembly. Therefore, governor could not have asked the government headed by Uddhav Thackeray to seek a trust vote on the floor of the House on the 30th of June. On this basis, the governor's decision rather placed a premium on the unconstitutional acts of a faction in the legislature party, allowing them to topple an elected government. He knows because he is not a member of the assembly, but he is part of the legislature. So he knows. So he went outside the scheme of the 10th schedule as well as the scheme of the constitution to recognize a faction. Majority or minority doesn't matter. The governor is knowing fully well that a faction of the legislature party cannot be recognized under the constitution.
Sorry, just to pause here. According to you, suppose there is a split, which is now, of course, not recognized.
Yes.
So, what would have been a split under the unamended provisions of the 10th schedule? But there is a group of legislators who would otherwise, who have otherwise left they say we have withdrawn support.
Correct.
Right, whether they withdrew support here or not, that you already made your point. Now, they will incur a disqualification because there is no split which is recognized by the 10th schedule now.
Yes.
Can the governor not then look at the numbers and say that, assuming that these people say that we have left, whether they incur a disqualification will be decided by the speaker, but this conduct of these people in doing something which is contrary to the 10th schedule also is liable to affect the strength of the House and the strength of the number of parties in that House, or the strength of the party in that House. Can he not do that?
No.
Because your argument is he can't do that at all.
No, forget Malad, the majority. This can happen, Malad, where 2 or 3 or 4 members of each political party can do the same. What you're doing is, Malad, when there was no 10th schedule, what used to happen? The same thing. What my lord is putting to me used to happen when the 10th schedule was not there.
Right.
So you are going back to a state where the 10th schedule is not there. That's my answer. Because that's exactly what your lordships are putting to me. Can't the governor, looking at the fact that these people now say they want to withdraw support, they may be disqualified. That's a separate issue.
Then your submission would be that the governor can't call for a trust vote in oblivious to the provisions of the 10th schedule.
No, forget the 10th schedule. He can't call for a trust vote, Maharaj, by recognizing a faction in a political party which has no identity, which has no constitutional identity. That's my submission. Maharaj, your lordships are now looking at them as a group. They are not a group, they are individuals. There is no concept of a group within the legislature. Each is an individual. And government formation is based only on alliances. And therefore, Malaj, calling a trust vote has to be based also on alliances. If it's been reduced to a minority. That's accepted now by Rameshwar Prasad, Malaj. They could have followed, Malaj, the Madhya Pradesh model. Resigned. No, but they wanted to be chief ministers and post, Malaj, so naturally, Malaj. they could have followed the other model. Well, that also is a constitutional issue which one day your lordships will decide. That's also another issue. The collective decision to resign as a group, well, it is something which is very suspect in constitutional law. Suddenly, all of them together one day decide we all must resign.
This is in line with Quixote, unless we question Quixote.
Well, I have always questioned it. I have always questioned it, but that's another issue, Malaj.
But it also has a bearing on coalition governments,
Yes.
particularly regional parties.
Yes.
Regional parties, this argument could sometimes be very dangerous also, because there is absolutely no freedom in the party, except for one leader. Many a times it's a family which runs it, and there is no scope of anybody else coming into the fray.
That's in fact,
and setting up an alternative, because it's impossible. Virtually, we are interpreting the constitution to say that it is just not possible for any legislators.
Malaj, in fact, this has been my grievance. What happens, Malaj, in the United States and in the UK, Malaj? A president, Malaj, of the Republican Party will reach out to Democrats to get a bill passed. The insurance, actually, Barack Obama had to reach out to the Republicans for his insurance bill. And in the UK, the same thing, the Conservative Party or the Labour Party reaches out to the opposition members. There is no such thing as defection. This is the problem. But anyway, Malaj, we are in another era.
Yeah.
At the moment, we are on the law as it stands today. So we go back to the Gyaram regime, where there is no 10th schedule, and you can actually move the governor for toppling any government you want at any time you want. Yeah, a few people. Malaj, there is an NCP case where only four people of the NCP, Malaj, actually went away. There were only 4 members. All of them went away. So it can happen.
So according to, going back to the Sarkaria Commission report, which was relied upon in Rameshwar Prasad, this was a post-electoral coalition of parties.
That's correct.
Of course, with the support of some independents as well.
Yes.
So according to it is only if any one member of the alliance and
Shifts.
or one member of the coalition shifts,
That's right.
that the governor can then say that, look, as a result of one party in the coalition, one member of the coalition having shifted,
Correct.
or ceased to back the government. Therefore, I feel now your vote in your confidence in the House, the confidence of the House in your government is now liable to be affected. Therefore, I call for a trust vote.
Therefore, he's not concerned with the 10th schedule at all, Malaj.
Right.
With the greatest respect.
Right.
Governor is not concerned with it. That's a separate proceeding. Whether they'll be disqualified, they may not be disqualified. If they vote against the whip, Malaj, within 15 days, I can condone it. Or if you have sent notices to 16, the others may say, now I don't want to lose my membership. They will come back. That arithmetic and that, Malaj, the consequences are not relevant as far as the governor is concerned or even the court is concerned. Court is to judge the act of the governor on the 28th of June, Malaj. Whether that was right or it was wrong. And I might say this to your lordships, Malaj. Malaj, when we enter this courtroom, Malaj, we are in a different aura. We come with hope, with the expectation that you are the only hope in this country. Power, Malaj, if you look at the history of civilization, all injustices are based on power. Whether it was the execution of Socrates, why was he executed? He was executed because he didn't believe in the Athenian gods. He was executed. The same thing is happening today. Not in that sense. Where do we go? Their formulas, this court's history has been so phenomenal, and your footprint is the largest around the world. You are the beacon, the hope of 1.4 billion people. And you can't let democracy be destabilized in this callous, uncouth fashion. I'm sorry, Mullah.
But then taking your argument to its logical conclusion, that means that the governor cannot really have regard to any individual movement of a group or a number of MLAs
Yes.
or MPs.
That's Bomai, Mullah. Yes, exactly. Para 88 of Bomai
Their
says that.
movement lies within the province of the Speaker
Yes.
under the 10th schedule.
Internal dispute he can't deal with. Para 88 of Bomai, Mullah. Intra-party disputes he can't deal with.